Hello, folks. Dustin Zarni here, Democratic Commissioner for Onondaga County. Today is Commissioner in a Car. It is Tuesday, August 13th, right? Yes, I got it right. Sorry, the days are going together. This Commissioner in a Car is a little different because I was going to talk about propositions on the ballot, and I decided I'm going to wait till next week or the week after on that. Because something came up in the news over the last couple of days, and I felt like it was important for me to talk about it, and that is RFK Jr., independent presidential candidate under the We the People line in New York. A recent court ruling stated that he will no longer appear on the ballot, and the reason he's not appearing on the ballot is because of a residence issue. And I thought, at first I wasn't really going to cover this, or I was going to just kind of talk about it, but why get into this? But there's been so much misinformation out there over the last couple of days, and I took some time today to read the ruling from Judge Christina Ryba on this, and I actually think this is actually a pretty important case here in New York, I wanted to talk about it because it's almost like a little mea culpa on myself, because when people were bringing this case to me a while back when it was first filed, I really didn't give the case much credence because residency in New York is pretty liberal. The definitions of residency are pretty liberal. If you say that you live somewhere, you're assumed that's assumed to be accurate in New York. That's the first assumption. You don't have to do too much to prove that when you register to vote. Boards of elections are supposed to take the information on the voter registration form and just assume that it is valid. And I assumed it was valid. Robert F. Kennedy has been supposedly a New York resident since the 60s. His father was a senator here. The Kennedys have had a long tie to New York because of that. And he's been a fixture around New York City politics and New York City social circles, forever. So, not knowing the facts of the case, I assumed that this case was, I don't want to say without merit, but I thought, it's pretty high bar to climb to establish that somebody doesn't live where they say they live. However, this case really kind of is going to be I think, if it's held up, and now remember, this is only a ruling by the Supreme Court in New York, which is the lowest court in New York. It will now go to the appellate court and then the Court of Appeals. And so there's going to be, and possibly to the Supreme Court. Well, I doubt the Supreme Court will take this up, but it's possible. We will see where it goes from here. But, absentee ballots go out September 20th. State Board of Elections has to certify their ballot by September 11th. My guess is that we will get at least the New York State rulings on this, the further rulings on this by September 11th. They will fast track these rulings and make a determination. So, we don't know that it's going to stick, but the more I read into this case on the press reports, it was such a wild amount of stories that I had to actually go find and read the ruling today. And I'm actually going to read from the ruling today on certain pieces that I think are very important for you to know. And I got some notes because I wanted to make sure I got all this right, because this is bonkers. I'm actually quite surprised at how bonkers it is, because this is a presidential candidate. And I know RFK Jr. himself has been a little bonkers, in the terms of vaccines and, you know, staging a bike accident with a bear 10 years ago in Central Park. I mean, like, there's a lot of weirdness around RFK Jr. And his candidacy. But this might be the most weird because it's so silly that it may end his candidacy in New York and maybe other states as well. This is going to be interesting. So the case revolves around his residency. He supposedly lives in a residence in Westchester, New York. That residence that he claims is his permanent residence is a single bedroom rented from another lady who owns a house that is apparently in foreclosure. And, and that he spends most of his time in California with his wife, actress Cheryl Hines, but he maintains this bedroom as his domicile for registering to vote in New York, as well as running for president. Now, you obviously don't need to be a New York resident to run for president and be on the ballot in New York. Obviously, Vice President Kamala Harris and, former President Donald J. Trump, although he was a New York resident while he was president, but now has moved his residency to Florida. Obviously, most of the presidents aren't residents of New York. You don't have to be a resident of New York to get on the New York ballot for president. But what you do have to do is when you're filing independent nominating petitions, you have to state your residency. And that has to be accurate and strictly adhered to. This is a very important, thing. The strict compliance part of this is something that is very important. So let me read to you my first bit from the court's ruling. Election Law 6140, parentheses 1, requires that each page of an independent nominating petition set forth the address of the candidate's place of residence. The Court of Appeals has repeatedly emphasized that although substantial compliance with election law requirements is acceptable as to the details of the form, there must be strict compliance with statutory commands as to matters of prescribed content. Strict compliance is important here because that's what this ruling is based on. So when RFK Jr. filed his independent nominating petitions, he put on his residency, this 84 Croton Lane residence down in Westchester, New York, that he said that this is where his residency is. That's where his permanent residence is. But we know that he lives a lot of time in California. So the court went on to detail what New York State election law says is, what are the requirements for residency in New York, and what election law says is the requirements. So I want to read that to you as well. The court's ruling said that according to Election Law 1104, subsection 22, and New York State case law, a residence is the place where a person maintains a fixed, permanent, and principal home, and to which he or she, wherever temporarily located, always intends to return. As used in the election law, the term residence is synonymous with domicile. Case law has also established that an individual having two residencies may choose one to which she or he has a legitimate, significant, and continuing attachment as her or his residence for purposes of the election law. The crucial factor in determining whether a particular residence complies with the requirements of the election law is that an individual must manifest an intent to reside there, coupled with physical presence without any aura of sham. Aura of sham. Remember that. Because that is very important in New York State election law. What it's basically saying is that that if you have a physical presence at a residence, or an intent to return to that residence, and an attachment to it, that you can use that as your residence for purposes of voting and being a candidate in New York. And thus, when you're putting it on your forms for independent nominating petitions or any kind of petitions, it would actually be legal and valid. However, in the court rulings, and again, I'll read a little bit more from that in a little bit, the court itself ruled that indeed Robert F. Kennedy's residence at 84 Croton Lane did rise to the level of a sham residence. In fact, what the court says the petitioners argue is that Kennedy falsely listed the 84 Croton Lake Road address as his residence on the nominating petition in order to perpetuate a decade-long sham that enabled him to retain his voting eligibility and political clout in the state of New York, which while actually residing in the state of California. So that is what the petitioners were alleging, the people who took him to court. And that's a pretty high burden to meet. So what happened here in this? And there have been cases brought that haven't met that burden and that people have remained on the ballot. But what happened in this case that allowed him to actually that got to this level of that they were actually thrown off the ballot. So the petitioners brought several different people to the court, several different witnesses to the court, and they actually established that Robert F. Kennedy not only doesn't live at 84 Croton Lane, they had no intent to return there, but also may have. So that not only did he not live at 84 Croton Lane, but he has a decades-long pattern of not living at the places that he said he had lived. There was a previous address that he said he used for voter registration, and his story there was that he was living there up until 2023, when the owners of the property asked him to move out because he was running for election against President Biden, and that the owners said that they supported President Biden. So that's how he moved to this 84 Croton Lake Road domicile, the little bedroom there. The people testified that not only is that not true, that the story about asking him to move not true, that he hadn't actually stayed overnight or been in part of that domicile since 2017, and that from 2014 to 17 he kind of was there, but they never thought of him as living there or for purposes of residence. So they established under penalty of perjury that they actually did not, that he didn't live there. That was the previous address to 84 Croton Lake Road. But so they established that. He maintained that he had a Jeep that was registered to New York, and that is true. He did have a Jeep that's registered to New York, but it was registered to a different address, not 84 Croton Lake Road, but to the address of one of his accountants. So this this fact pattern did not put Robert F. Kennedy Jr. in a good light with the court. And in fact, established that he may have actually had this decades-long sham, but that's probably not the meat of the case. The meat of the case came down to, does he live at 84 Croton Lake Road and or have an intent to return there. And because of that, I want to read a couple of sections from the ruling from Judge Ryba, because I think it's important to get the words down here, exactly what the judge ruled. So here's a pretty long paragraph that I want to read about his address and testimony about this. So we're talking about the 84 Croton Lake Road address. Furthermore, the undisputed testimony provided by Moss and Kennedy, Moss is the owner of 84 Croton Lake Road, established that there was no written lease for the premises, and that although they allegedly discussed a potential rental payment of $300 per month during their initial conversation of the spring of 2023, Kennedy made no payments to Moss whatsoever until approximately 1 year later on May 20th, 2024. And although Kennedy attempted to characterize that $6,000 payment to Moss as back payment for 1 year of rent, the credibility of this characterization is undermined by the testimony that Moss was not pressing Kennedy to make rental payments, that Kennedy made the payment 1 day after reading the May 19th, 2024 New York Post article that he told his assistant to send Moss $6,000 because of the foreclosure, and that Kennedy was completely unaware that the home where he had supposedly been residing for an entire year was under foreclosure until he read about it in the New York Post. Indeed, Kennedy's admission that he was not named as a defendant in that foreclosure action, had never been contacted about the foreclosure or served with foreclosure papers, and was personally unaffected by the foreclosure action, supports the conclusion that he was not a legitimate tenant of the property. This credible evidence clearly established that Kennedy lacked the necessary intent to make the spare bedroom of the 84 Croton Lake Road address his legitimate and bona fide residence. So that paragraph goes to about the intent portion of the residency. And again, he was not making payments until after the New York Post article in May that showed that he probably wasn't living at where he said he was going to live. Then all of a sudden he cuts a $6,000 check to the owner, and it says, well, I didn't know about the foreclosure. Well, it's kind of hard to live in a house if you're actually living in a house and not know about the foreclosure, and so he doesn't have a physical attachment to the property. I want to read from another portion of the ruling. Again, a little bit of a long read paragraph, but it goes to the other portion of intent to return. So it wasn't just that he doesn't have a physical attachment now. He could have a residence if he had an intent to return to the address. But the court addresses that in this paragraph. The clear and convincing evidence at trial also established that Kennedy lacked the requisite intent to return to 84 Croton Lake Road. Indeed, Kennedy himself testified that he lacked any present intent to return to 84 Croton Lake Road address. While Kennedy had testified that he intends to return to the state of New York when his wife retires from acting at some undefined date in the future, the testimony is speculative and wholly inadequate to establish a present intent to return to the spare bedroom of the 84 Croton Lake Road address. Given the size and appearance of the spare bedroom, as shown in the photographs admitted into evidence, the court finds Kennedy's testimony that he may return to that bedroom to reside with his wife, family members, multiple pets, and all of his personal belongings to be highly improbable, if not preposterous. In addition, Kennedy's testimony that he would buy another house in the town of Bedford if it is not convenient to move his family pets' belongings into the spare bedroom at 84 Croton Lake Road is both speculative and immaterial to the issue of residence. The fact that Kennedy considers himself to be a New Yorker, has fond memories of the years he lived in the town of Bedford, and longs to return there someday, is utterly irrelevant to the issue of whether he resided in the spare bedroom of the 84 Croton Lake Road address during May of 2024 when he circulated and filed the nominating petition. So the ruling from the court is actually pretty clear. The ruling from the court is way more definitive than I thought it was going to be, and mainly because of the actions of Robert F. Kennedy Jr. here in putting this address on his nominating petitions in May of 2024, when indeed he was a resident and lived in California, and that is where he should have been voting, and let alone the fact that he may have been voting, I don't want to say illegally because that's a finding of the court, but improperly in New York for the last 10 years, as he didn't have a clearly established residence here. But of course, his residency also wasn't challenged during that time period. So now that his residency is being challenged, the court found that he doesn't have the ability to be a resident there. Thus, by putting that address on his petitions, it was false and not strictly complying with the form, with the mandatory statutory compliance, statutory required information that is on the form that you put the independent petitions in. Candidates have a special burden to meet when it comes to that. They have to comply with the law, and it looks like Robert F. Kennedy Jr. did not do so when he put down 84 Croton Lake Road as his address for the independent nominating petitions that were filed in the state of New York. Thus, the candidate, not only had a sham address that he was registered to vote at for a decade, but he put that on his form, and thus his nominating petitions, which is his ballot access method in New York, has been ruled inadequate and false, and he is off the ballot in New York. Now, each state has different rules, and it's unclear at this point, at this late date, whether this ruling from New York will go to other states. I'm not a lawyer. I should have said this right at the top. I know New York election law pretty well. I know ballot access method pretty well, but I'm not a lawyer. But I can tell you that we're getting kind of late in the calendar here. Some states, I think North Carolina, starts early voting on September, right after Labor Day there, or September 6th or something like that. New York has to send out absentee ballots, and in fact, federal guidelines are we have to start sending out absentee ballots and vote-by-mail ballots on September 20th to federal and military and overseas voters, as well as the rest of our voters as well. So that's about 5 weeks away. There's not a lot of time for the courts to start proceedings on this in other states that maybe don't already have proceedings happening. There's also not a lot of time for appeals for this ruling as well. The appellate court will probably hear this. They'll probably hear it pretty soon. And then the Court of Appeals will probably hear it pretty soon after that. So in New York, we'll probably get a final ruling. But I don't know what's going to happen in these other states. The group that brought this lawsuit has said that they're looking into other states. Of course, Robert F. Kennedy and his group has said that they're going to appeal this all the way up to the Supreme Court. It's far from over. But I got to be honest, this ruling and the fact pattern laid out in the ruling, and I didn't go into some of it, but there's a lot more in there as well. The fact pattern laid out in the ruling, including Robert F. Kennedy's own words on the stand, really established that he is not a resident of New York and never intended to return here, not in a reasonable way, and definitely not to the domicile that he was in. So why would he do this? Why would he put this wrong address out there starting in 2023 when he registered to vote there? Put it on the independent nominating petitions in May, when he could have just used his California address. And if he used his California address and registered to vote out there would have been no issue. Well, some may have speculated because his vice presidential nominee is from California, and that would put in peril any electors that they might win in the presidential election, because the electors from the same state can't vote for people from the same state. So no elector can vote for a president and a vice president from the same state. But that happens after the election. I'm not sure that would keep them from getting ballot access. But that could have been a possible motivation. It could have been, he said it was his advice of counsel. In fact, his counsel testified to that effect, that he felt that this was in compliance of New York State election law, and this is where he should do it. It could be the fact that, he's been voting here in New York, and it could be that he just thought it was right. I don't want to speculate to why he did this, but when you're running for the highest office in the land, you have to actually, be able to fill out the paperwork and properly comply. And it is kind of ridiculous that a man of his means is renting out a $300 a month spare bedroom, a very small spare bedroom where he has, and the court paperwork goes into this. It's not just that he's renting out this bedroom. He has no physical presence there in terms of any possessions of his. It's everything that's in the bedroom. There was pictures was not his property. It was the property of the owner, including all his bedding and anything else that was in the room. He had no physical property there. He did receive mail to that address, but he never collected that mail. In fact, the owner, knowing that he would not be there, testified that she would send that mail back to California or to his accountants, and he wouldn't collect that mail. So there's a lot of other things that were in this case that didn't necessarily make it out into the press reports, but is in the ruling itself. And I got to be honest, I might put this on my website with the commissioner in the car, on the commissioner in car page. I might put the ruling out there because I think it's something that is pretty easy to read for a layman or a layperson to go through. Non-lawyer. I'm not a lawyer, so I was able to read it. But I also know election law. But still, if you're reading the testimony, reading the judge's ruling here, it's pretty clear what had happened here is that, Mr. Kennedy decided that he wanted to be a resident of New York. He wanted to continue to have his registered vote here, yet still living in California, and that is where his residence was in terms of his everyday life. And again, why he didn't buy his own property? If he had bought a house here, he might have been, might have been able to say, yes, I have a physical attachment to this community, not just a spare bedroom where he's going to, bring all of his spare belongings, including his wife, in an intent to return there. So, again, and while dual residencies are allowed in New York, they're usually in the case of people owning two different properties or having leases, in two different properties, having their physical stuff, their materials in two different properties, and then they choose one for voting residence. Here it just seems like he had a verbal agreement with someone to rent a bedroom that he didn't pay for until days after a story made it into the Post, and those payments were actually an attempt to show legitimacy of something that wasn't really legitimate, and for at least in the purpose of residential voting. So why am I spending a lot of time in a whole episode on this? Well, I think it's interesting. So boards of elections have come across people saying that, well, this person doesn't live where they live. And there are voter registration challenges that can go on. This case kind of establishes like a textbook case of if you were going to get yourself thrown off the ballot, if you were going to get your registration thrown out, you would do this. You would have a place where you say you live, where there's no lease, there's no actual records of payments until the time that the inquiry starts, and that you have, you never visit, you're never there, you never pick up mail, you don't have any of your physical things there. Your car is registered in New York, but not in that address. That you're a pretty wealthy individual living in a pretty wealthy and large house in California, and that you wouldn't be able to bring all of your contents to this one domicile and live there. So it's if you were going to get yourself thrown off the ballot, that's how you do it, and this is how he did it. Because these are the facts that are matter. Now, you could say, well, it shouldn't matter. You're taking 100,000, 30,000 people who signed his petition, and they probably didn't care about where he was residing. They cared about his name, and that's what is important here. But the problem is that the petition itself had wrong information on it. Do I think anybody actually would have not signed his petition if he had his California address as opposed to his New York address? Well, maybe not. But we don't want to open up the pattern that candidates can just put any kind of information on a petition and turn it in under penalty of perjury, under that you have to have strict compliance, and then we just say, it doesn't matter at this time because we feel bad. And especially in a case like this where, again, and the court ruling actually goes into other court cases where there was a mistake that was made, where a previous address was used, where they lived, where the candidate lived. But that's not what happened here. It wasn't that he used a previous address that he had a strong attachment to. Is that not only did he have no attachment to this address, he probably had no attachment to his previous addresses since 2012 when he married his wife, and 2014 when he decided to move to California. So that's about 10 years there. That's a long time that he probably did not have any real established residence. In fact, they go into one of his resignation letter to one of his agencies that he was in, and that resignation letter, he talks about how he lives now in California, and that the commute to New York is too much, and his carbon footprint is too much to continue on with this. He's not ever really saying, but I intend to return here later on. So, every bit of fact, every bit of evidence seemed to point to that he does not have a residence in New York. So I think I've explained that as much as I can. It's a weird thing, but we'll see where this goes. My good friend David is in the comments where he's talking about, is it wise for campaigns to label their opponent weird and not talk about the substantial issues in a campaign? Come on, David. The opponents are weird, and they do talk about substantial issues in a campaign. There's been the whole topic about Project 2025 and all of this other stuff. But you know what? Sometimes people are weird, and sometimes it's okay to say, hey, they're weird. But there have been substantial talk about the issues of this campaign by Vice President Kamala Harris and Governor Tim Walz. He also asked, can the 12th Amendment be amended to end this weird issue with not allowing two people from the same state to run for president and vice president? Sure. The 12th Amendment always can. Any amendment can be amended. We can have another amendment to the Constitution, but that's not the state of play now. And I would like to actually amend the Constitution to get rid of the Electoral College altogether. How about that? But we got, but amending the Constitution is a decades-long process, and probably not in the cards in this divided government anytime soon. And then finally, David asked me, can I talk about the lawsuit around Amendment 1 language that is supposed to be on the ballot in November? I'll talk about it in brief, and that's one of the reasons why I decided not to talk about the propositions this episode, is because we don't know what the final language is. So I like to talk about lawsuits after there's a ruling because then I have something to talk about. But Proposition 1 is the Equal Rights Amendment to the New York State Constitution. It enshrines the right for abortion and other things into our Constitution that isn't there now. There is the amendment as written by the State Board of Elections and agreed to by the Democratic and Republican commissioners. The people who are starting the lawsuit believe that amendment language is too complicated. We passed a law a few months ago that said that, or maybe it was last year, that any propositions that go on the ballot have to be equivalent to an 8th grade reading level, or no higher than an 8th grade reading level. And the people who have done the lawsuit believe that the language that are put forward by the New York State Board of Elections is a 13th grade reading level. They believe that there's other language that this court can put forward that will go on the ballot. That lawsuit is going forward. Again, I'm sure that'll be heard and decided by September 11th. But until we get a ruling on that, I'm not going to go much into that because I'm not a lawyer and this is a brand new law. So there's no even precedent. This case will set precedent based on that 8th grade reading level. So that's what is going on there. So I'm hoping in a couple weeks I will do a final or an episode on propositions. We only have 2. We have the statewide ERA, and then we have a proposition from Geddes, which is moving their town supervisor from a 2-year term to a 4-year term. So I'll talk about that in a future episode, probably, in a couple weeks when I get a ruling on this proposition to see where it's at. Well, that's all I got for Commissioner in a Car. Thank you so much for tuning in and looking at the Robert F. Kennedy saga with me. I will once I get this all posted up in the next hour or two, I'll have the court ruling on in the show notes that you can follow along with. Thank you very much and enjoy your day. Bye-bye.